watch from home. We are back on Senate Education Tuesday, April 25th, 3:09. Ms. Barquist, you've asked to weigh in on the language that Boer-Yang put forward to add to the miscellaneous education bill. And if you were here earlier, you would hear that the committee's still struggling a little bit on this. We heard Ms. Sklowski is here. She mentioned, and Ms. Sklowski, to confirm, you were representing that day. The NEA, everybody was saying, don't move forward.
Yeah, the Boer Association.
The Boer Association.
Yes. Yeah.
So, and so this has to do with severe and pervasive standard of bullying and harassment. So with that, the floor is yours.
Yes, well, hopefully I won't confuse your decision too much, but maybe offer you some clarity. Jessica Barquist, Policy Director at the Vermont Network Against Domestic and Sexual Violence. And we strongly support the amendment that was offered to H461 that will strengthen the bullying and harassment language in our education harassment statute. We are generally supportive of reforms that improve our system responses to harassment and discrimination at an earlier intercept before victims experience long-range impacts. Harassment based on a student's protected characteristics can have long-term and detrimental impacts to both their mental health and their education. In particular, we want to highlight the importance of this bill in addressing sex and gender-based harassment. Sexual harassment is a form of sexual violence, and this can take many forms, including unwelcome or unwanted sexual advances and sexually explicit and offensive conduct. These behaviors can create a hostile and abusive educational environment. Last year, we worked with Boer-Yang and others to support the efforts to address the severe and pervasive standard in Vermont law. And that is across a number of different settings: employment, housing, public accommodations, and educational. We were pleased to see that harassment standard amended for housing last year. And this year we're working on an amendment for that standard in all public accommodations. The severe and pervasive standard, which originates from case law, creates an exceptionally high barrier for individuals to bring forward meritorious claims of sexual or gender-based harassment. Victims and survivors who have experienced long-range discrimination or a singular severe instance of harassment have been prevented from bringing forth claims due to the standard. As with many forms of sexual violence, individuals occupying more than one marginalized identity, such as race or gender identity, are impacted by issues of harassment in much more complex ways. Under the severe and pervasive standard, students with intersecting identities must prove that they were subject to severe or pervasive harassment on each separate basis. The totality of all harassing behavior and its impact cannot be adequately addressed with the current standard. S103 is currently being considered in the House, and that would change the severe and pervasive standard in employment and other places of public accommodation, with the exception of educational settings. And if we are to change the severe and pervasive standard for employment while carving out educational settings, school employees subject to harassment and discrimination will be treated differently than students. And just to underscore this, that schools will become safer for their employees than for students. So if the same teacher sexually harasses both a colleague and a student, that adult, that colleague, the other teacher will have more protections from that harassment than the student, than the child. Many states of public accommodation, including healthcare settings and prisons, have statutory and institutional policies already regarding harassment and discrimination. And while it is true that we are expecting new Title IX regulations to come out, hopefully in the next year or so, those represent the minimum standard of protections that institutions must offer. Vermont can and should do more to offer students protection from harassment and discrimination. Students deserve the right to pursue a claim for harassment under the Public Accommodations Act. And there were two very impactful examples presented in the House last week, which I'd like to share with you related to how this standard hurts our students. So MH was a 9th grade student in New York when a classmate attacked her in a stairwell, pressing her against the wall with all of his weight and groping her all over her body. While she tried to push him off and told him to get off, this was very clearly a sexual assault. But a federal court held that the sexual assault was not severe enough because she was not raped. 9 federal, in other words, the court said that any sexual assault that is not rape is not severe enough. And then a female student in Georgia from the 10th grade, when an older student forced her to perform sexual acts on the school ground. The federal court said the act happened in only a single incident, so it was not pervasive enough because she was not attacked on 2 separate occasions. Many other courts.
If you would pause right there for a second, if you don't mind. So if these happened in Vermont right now, and we did pass this amendment, then they happen. This is allowing a student to do what that he or she would be able to do under current law.
Yeah. So this amendment doesn't hold students liable for harassment.
Right.
It holds the schools liable.
Okay.
And so it allows students to receive those supports and protections that they need, but it doesn't dictate how schools should follow up on that discrimination or require a certain disciplinary to take action. And if it did, we would not be supporting it. And just for context, there are many ways for schools to be able to address this harassment without discipline. First and foremost, schools should provide victim-centered responses. And that means offering supportive measures to help the harassed victim feel safe at school, like a safety plan so they don't have to be in the same classroom as their harasser, or figuring out so they don't have to run into their harasser in the hallways or at recess, lunch, or on a bus. If a harassed victim starts skipping school because they are afraid of seeing their harasser, a school can excuse those absences instead of making them truant. If their grades have gone down or they are having trouble studying or learning, the school can give the student a tutor to help them catch up on schoolwork or an extension for their homework. If there are so many different ways that the school can offer supportive measures. And even for the harasser, right, there are many things outside of discipline that the school can do to connect them to a mental health counselor, to help them understand, to help them with past abuse or trauma in their life. The idea here is that the schools are liable to do something to address the harassment instead of do nothing.
Can you say a word about elementary versus middle versus high school students? Everybody treated the same way, or the school is held accountable in the same way?
Yeah, I mean, I have some statistics here for you that are mostly older students, but yes, I think all students should have the right to a school environment free from harassment or discrimination. And just to give you some of those statistics, data collected by the U.S. Department of Ed, about 1 in 5 U.S. students ages 12 to 18 have been bullied between 2015 and 2019. 1 in 4 students bullied between 2018 and 2019 were bullied due to their race, national origin, sexual orientation, religion, disability, or gender. Additional data from 2021 detailing the impacts of the pandemic found that the risks for sexual and identity-based harassment disproportionately impact students of color, girls, and LGBTQIA+ students. Vermont schools are not immune to harassment and its harmful impacts on students, according to results from the Vermont 2019 Youth Risk Behavior Survey. 45% of students have been bullied on school property. Feeling sad and hopeless increased among Vermont high school students from 25 to 31%, and among middle school students from 19 to 23%. There was an increase in the number of high school students who hurt themselves without wanting to die. That went from 16 to 19. Made a suicide plan from 11 to 13%, and attempted suicide up to 7% from 5%. So this legislation essentially just puts more tools in the toolbox for adults to help protect our children in our school systems. And by amending the education code to amend that severe or pervasive standard, you all would send a message to Vermont residents that harassment based on sex, race, disability, religion, age, whatever, will always be taken seriously, regardless of where it occurs. And possibly even most importantly, you will be helping to educate kids at a very young age that harassment in any place is not acceptable. And this will help to ensure not just safer schools, but safer workplaces and safer public places for all Vermonters. So thank you so much for squeezing me in today and for your time and attention on this.
Thank you.
Yeah.
Committee questions?
Just one. On the second page, you have a comment on school liability. And it says this amendment doesn't hold students liable for harassment or discrimination, holds schools liable. I'm just wondering if the intent of that sentence is a positive or a negative effect.
It's a positive. I think there have been some testimony, I'm not sure if it's this committee or in another committee grappling with these issues that concern that the end result would be that students would end up being expelled or further widening their gap of support services. And so what I was trying to say there is that this places the onus on the school to address the situation versus placing the onus on the student causing the harassment or with any sort of disciplinary measures.
Okay, so I just wanted, while you're here, just curious if you can comment on where the student and parents' responsibility begins.
I mean, I think that the parents and students do have a responsibility, but that the school also has a responsibility to support them in that education. And that's part of what we do in schools is we learn from our mistakes, and the school needs to be able to support the students and the family in being able to go through that process. Yeah.
Ms. Zaglavsky, do you mind just weighing in again on this? This is starting, as I read it, it's starting to sound much more reasonable to me than my initial thought. Can you just say again why you're opposed to this? Why you, the NEA superintendents? You can stay right there. No, sorry.
My testimony on Friday was not that we are opposed to it.
Okay.
My testimony was that our testimony is that you should wait until the federal Title IX regulations are issued because they cover a lot of the same areas that this amendment does. And I think it'll be helpful for you to hear from Attorney Heather Lynn. She's up next on your witness list, and I think she'll be able to go into a little bit more detail on that.
But even if the feds come back and say June or whatever, saying this, fine, why not get this started? What if they come back and not?
I think that, oh, I'm sorry, were you directing that to
Well, I
me?
was gonna actually.
Yeah, I will just
First.
comment that you all have already passed S-103 and it is up in the House
Yeah.
that is likely to pass around employment, changing this. So schools are places of employment and they will have to change their policies anyway as it results to their employees.
Right.
So they
S-103.
will already be updating these policies regardless of when or what comes from Title IX.
For teachers and staff, other personnel. Yes, Senator.
So I'm just looking on page 2, and then there's the statement of, while it's true, we're expecting new Title IX regulations to come out next year or so. They represent the minimum standard of protections that institutions must offer. Do you have any details on the differences that would be created if we were to pass this amendment and then compared to what Title IX changes would come down the road? Do you know what? Okay. Yeah. Okay. No problem.
There's no such thing as a draft that's been circulated.
There is, and my colleague Carrie Brown might have more information.
Brown, do you want to
there.
say, introduce yourself?
Carrie Brown, Executive Director of the Vermont Commission on Women. The proposed changes are available. They are expected to come out very soon. In judging by past history, generally speaking, the final regulations that come out after a period of public comment tend to match the proposal, and there's no guarantee that they actually will. But so we have a pretty good idea of what they say. So the Agency of Education will need to be making changes to their model policies on hazing, harassment, and bullying because of the Title IX changes that are definitely coming. So that is,
Which are, can you tell us mean, that's, I think, what we're trying to get, at. What's
Oh,
coming.
what's in
Is it-
them?
Does it look like what we're trying to do right here, or is it less?
No, it's less. It's, there are a lot of things in there that have to do with like timing and procedure and that kind of thing. They are using still the Surveyor or pervasive standard as a basis. And so in that sense, it is not providing the same level of protection as this change would. So to bring S103 to match what's going on with education. So it's a lower standard of protection, if you will. The Agency of Education will be revising their model policies in response to the Title IX changes. And so if we don't make these changes now to the education law and make them later, then it will be two different revision procedures that will have to happen. So if revision needs to happen, it makes a lot more sense to do it all at the same time if this is the standard that you want.
That's exactly, thank you for that. That's one of my concerns too now is the two different revisions is it just wouldn't really make sense to do that in my opinion. Because if we're talking about waiting until Title IX and then having AOE revise their rules twice, it just seems like a waste of resources and a waste of time if we can do something that's stronger for students.
Senator Gillis, what do you think?
I mean, you've heard what I've had to say.
Yeah.
I just, I'm concerned that there may be some unanticipated consequences for some of our most vulnerable students. I'm prepared to be proven wrong. To a certain extent, I hope I am, but I would just ask that we have some folks from our equity office come in to speak to this in Burlington and maybe in Winooski and maybe even in Essex as well. In Colchester, just some of these schools, I'd love to hear from them and what they have to say. And I hope I'm off base. I just don't want.
Would you work with Kate? Just bring in a
Sure.
couple more witnesses
Yeah.
tomorrow. That would be great.
Well,
Or
this
Thursday.
week is tough because it is school break. Some people are away, but I'll try.
Yeah, that'd be
Yeah.
great. We can try to move this. Senator Gulitz, the unintended consequences piece. Ms. Berquist, can you say something about that? How are you feeling about that? Because one of the things that the committee talked about last week was what if a student or participant said something inappropriate, meant no harm? What if somebody was just going about learning what life is like, and we don't want to jeopardize their future in any way?
I can totally appreciate those
Uh-huh.
concerns. And I think that's why I said that if this bill dictated disciplinary measures for the harasser, we would not support that. But what we're hopeful that this amendment does is allows the school, because even if the person who said the harassing comment, it was part of their personal learning journey,
Right.
that harm is still real and that victim is still deserving of a response from the school and support from the school. And that's what this amendment is trying to do.
Yeah,
Well,
totally agree.
Yeah, that's really, that's helpful.
I was just scratching my face.
Sorry. And the only other thing I would say, I want victims to be protected. I would also say that, again, having worked in education for a long time, I think a lot of times kids whose behavior is erratic have also suffered trauma and various other travails in their lifetime. So
Yeah, and our hope is that schools will address that in a trauma-informed and sensitive way too, instead of expelling that student, but really working with that student to get the supports they need so that they can be a big member of our community as well.
So again, in this, there's no disciplinary measures taken for the harasser. This is more, hey, it was, no matter who said it, how they said it, whether they are right and wrong, we're talking about the person that was harassed. And the school now needs to take steps to make sure that maybe those two people, even if it was unintentional, this person's not feeling great about it, don't interact, have maybe aren't put on the same team, all those kinds of things to make sure that person
Yeah,
is comfortable.
Really.
And if that doesn't take place, then that's when the school could be held accountable.
that's
Which
right.
leads me to ask, what does accountability look like?
That is not a question I feel prepared to answer, but I can do some more research on my colleagues who have been working on this a little bit more details than I have.
Yeah, I'd appreciate if you bring that back. Generally, rarely are we in the finding business, are we in the, so what does that look like? That would be.
I believe it's a civil process
Uh-huh.
where the students can address harms that have happened, but I will make sure I have that accurate for you. Yeah, essentially it's saying the schools have to address it instead of sweeping it under the rug
Yeah.
or pretending it's not existing.
Yeah.
I
Senator
apologize.
Gillis.
It's okay.
The only other thing I would say one other thing really, is that if we are to do this, I would just, again, given the capacity of our schools right now, we've heard over and over and over again that they're lacking staff, they're lacking capacity, they're lacking resources, that maybe we have an implementation timeline. And again, I would want to hear from schools, but maybe some kind of a timeline for them to get there. I don't know, I'm throwing that out as a possibility. A couple of years, I don't know. I'd have to hear from-
I mean, my just initial is a lot of stuff could happen in a couple of years. We're about trying to improve the lives of kids, and I know you are as well. It's just, yep. Thank you. Thank you very much. Our next. Great. So on the same topic, Heather Lynn. Ms. Lynn, there you are. How are you?
I'm well, thank you. Good afternoon, everybody. Thank you for
Good
that.
afternoon. I don't know if you've been listening in, Ms. Lynn, but we just had some testimony from the Network Against Domestic and Sexual Violence on this bill. And I think that testimony helped at least me personally better understand what it would do and how it would do it. But we know that you sent along some concerns. So if you have
Yes.
some kindness to share those concerns after you introduce yourself, that would be great.
Thank you. My name is Heather Lynn. I'm an attorney. I work out of Burlington, Vermont. I was born and raised in Vermont, and I have worked with school systems for over 20 years, focused on responding to inappropriate student conduct, whether it rise to the level of harassment, hazing, and bullying, or other areas of code of conduct violations. And just a little additional background on what I do. I'm appearing here on behalf of the Vermont School Board Insurance Trust. And my connection to that organization is one that also stretches 20 years. In my work, what I do on a weekly basis year round is on any given day, you can see on my calendar, time set aside for me to do a training or a seminar on harassment, hazing, bullying, the definitions, a deep dive on the process that schools must follow when that information that relates to conduct that might, and that is the standard, might be HHB, not it's absolutely true, not we've proven it. If we think it may be going on, then schools automatically are compelled already under current law to document what is known, to get that information to a building administrator and have that building administrator assess the information, lining it up with the standards with a generous approach to meeting that standard and lean in under the standard that is under the Vermont Agency of Education's current procedures. Their model procedures for the prevention of harassment, hazing, and bullying mandate when that information lands on the administrator's desk, if that information provides them with just merely reasonable belief that a policy violation may have occurred, they shall investigate that information. And then the investigation will look into what has happened, surrounding circumstances, surrounding facts, an understanding of the dynamic that may have been at play and at work, and then find whether or not the policy was violated. And if not, well, did something else go on that still was disruptive to the educational environment that requires a response by the schools? And so the work that I've been doing for 20 years has been providing schools and the resources to support that work. And you can take a look at those resources if you want. They are available on the VSBIT, and that's VSBIT website. If you just Google VSBIT and toolkit, you will see my work, resources in detail, tailored to administrators, staff and faculty, superintendents, school boards. And within that kit is an itemization of every current duty imposed by law, federal and state, for schools to respond. So with respect and appreciation of the other perspectives that have been brought in front of the committee, it's simply not accurate to say that schools currently don't have a duty to respond. That duty under Vermont law has existed for over 20 years. The current iteration of the way in which schools respond in detail is contained in AOE's 2015 model procedure. That's what's currently up for review. I've submitted my proposed amendments to the agency. There are loopholes that need, fixing, but those procedures tell schools step by step. And forgive me, I train on this so I can get kind of wound up and into the weeds. But I want to turn my commentary now to the topic that is raised by your proposed bill and some of the testimony that you just received, which is around sexual harassment. Sexual harassment is currently prohibited in Vermont schools in two ways, under federal law and under state law. The state law definition is contained in the AOE model policy. There's a policy and then there's a procedure. And if you look at the model policy definition, it indeed does contain the severe, persistent, or pervasive language. However, it continues with these words, so as to deny or limit the student's ability to participate in or benefit from the program. You will never hear out of my words at any of my trainings or in any consultation with a client, and I do this work all day long. Oh, what you're describing to me is not going to be severe, persistent, or pervasive. I don't even focus on those words. All of the action is on the deny or limit. How much does it take to limit somebody? Just one fraction less than 100%. So what we're looking for when we're considering sexual harassment under Vermont law in schools is it having any impact at all? Now, let's take the example where a student is on the receiving end of behavior that is otherwise falling under the category of sexual harassment, but there is no discernible, discrete, or latent impact at all, which is frankly hard for me to imagine, but let's just put that up there as an exemplar.
Can you give us an example? Can you just give a?
It would be very difficult for me to think of an example of sexual harassment where a student is not feeling some level of impact. But if that were true, you still, under your current system with no changes, prohibit behaviors in school where you don't need to prove any impact at all. And that is your definition of bullying, which this body enacted back in 2005. And that is a very strict standard, and I think it's unique in the country. All that is required is for the behavior to happen more than once. So where a student is on the receiving end of sexual harassment, very typically there are a cluster of behaviors But even if there is only one, the student can be fully warned. And then if they engage in, quote, any act that has an intent to ridicule, humiliate, or intimidate, even if it's not on the basis of sex, and even if there is no discernible impact from that second incident, if it happens in school, bullying has occurred. So we have a constellation of protections under Vermont law. But in addition, I heard from the prior witness the concern that students are often also members of other protected categories. And the suggestion that if that were the case, those other protected category methods of harassment would somehow also require the severe persistent standard. And that's just not accurate. The general definition of harassment, which is in 26A, which is a focus of your bill, 16 VSA subsection 11, and then 26A defines harassment generally. There is no severe or pervasive language anywhere in that. So if a student who is a member of a minority religion is the target of behaviors and the target of behaviors on the basis of sex, the analysis from the school is not going to be whether or not there was severe, persistent, or pervasive behaviors with respect to the religious-based behavior at all. That standard in 26A, which I outline in my testimony, and you can review that also at your leisure, looks for one of 6 potential impacts. Any one of the 6 will get you over the hurdle. But again, in my example, if they're on the receiving end of behaviors that are based on religion and also on the receiving end of behaviors on the basis of sex, that's 2 acts of intentionally demeaning or ridiculing behavior, which gets you to bullying. My point is that there are a lot of obligations under Vermont law which coalesce to provide protections for students already. My second point relates to federal law. And I heard discussion in the prior witness's testimony around how we need to ensure that schools step up and start providing supports to students right away. That already happens and has happened explicitly since 2020 as a result of the first set of Title IX regulations. Those dropped in May 2020 and became effective in August 2020. Once a school has any information that sexual harassment might be occurring before even an investigation is launched or even decided to launch, the school shall meet with the victim and provide supportive measures, which shall include safety plans, alternative work schedules, alternative settings, escorts if necessary, anything and everything that can reasonably support the student in a way to remove the impact of the harassment, which the school at that point, frankly, operates under a as if it had occurred basis. They don't wait for the end of an investigation to then decide, and now what do we do to help the student? They immediately meet with the victim, and if they're a minor, which is most of the time their parent, and say, we're just presuming for purposes of the conversation this happened. We want to know, how is it affecting your access to education right now so that we can close and remove that gap immediately? That must occur under federal law. And any changes the Biden administration makes with their regulations that are dropping in the next couple of weeks will not change that. In fact, they will only increase the duties to provide supportive measures. That's what we've been shown with the proposed rulemaking, is that they are increasing the duties and the obligations of the school's Title IX coordinator to redress any sexual harassment that is occurring in the school. So we have a very vibrant network and obligation imposed by federal law right now. In addition, the changes the Biden administration are contemplating do address the severe and pervasive standard. And I sent to the committee earlier this morning, and I recognize I was supposed to get everything to you a day in advance, but it was this morning that I saw that a question had been raised on Friday as to what was the content of those regulation changes. And so I sent to you the summary of major provisions of the DOE's Title IX Notice of Proposed Rulemaking. And under the proposed regulations, they are considering changes to the severe and pervasive standard. I'm looking through my notes, frankly, to find the detail on that precisely. But I can also stop and take some questions. I know I've been going on sort of monologue-y, and from the video, I can't quite read the room. So I will pause for a second as I look for that citation. Yes, it's actually right on page 1 on that document, where it says that the current regulations prohibit unwelcome sex-based conduct only if it is so severe, pervasive, and objectively offensive that it effectively denies equal access. The proposed regulation would cover harassment that creates a hostile environment that is sufficiently severe or pervasive that, based on the totality of the circumstances and evaluated subjectively and objectively, it limits or denies a person's ability to participate in or benefit from the program. Much of the testimony that I reviewed centered on concerns that have arisen through the development of the law in the employment law context. And I point that out because the considerations in an employee-employer situation in terms of being able to regulate behavior and set standards for behavior are unique and different than in the education context. When we seek to regulate the behavior of essentially a third party, students are not contractors, they're not direct employees, they're not supervisors imbued with the apparent authority of the school to act and operate on behalf of the school. They come to the school with their own values, their own backgrounds, their own behaviors. And so our ability to regulate their behavior must be tied to the educational environment or educational purpose of the school. For that reason, for example, we know that when we attempt to regulate speech through T-shirts or the carrying of insignia and things of that sort, schools are limited, even if those are deeply offensive to other peers in the environment, except where the school can demonstrate that those symbols or those pieces of clothing disrupt the education environment. And what seems to be proposed or is proposed in the current bill would strip away consideration of impacts in the school at all and simply insist that schools find students as having harassed because of motive alone, without consideration of the circumstances, the impacts, and the ongoing dynamic between students. And it's our concern that this is going to, in fact, rebound against expanding rights for the students who you're seeking to help, because it's simply going to result in lawsuits filed against schools on constitutional law bases. We have already seen the current procedures and policies attacked in litigation by groups like the Alliance for the Defense of Freedom on a constitutional basis. But until now, none of those have been successful. I have strong concerns that with the change to the law that's proposed in this bill, which would strip away that link with educational performance, access, or indeed environment, it opens the door to successful litigation. And as I always am telling my clients, it is super important if you're protecting students to never have to walk back what you have done. So I have strong concerns that uncoupling those two concepts with the proposed legislation in an effort to address concerns which largely have arisen and existed only in employment law contexts and doesn't take into account the current regulatory structure that we have already in place, would be misguided. And lastly, I will say in the 20 years in which I've been doing this work, the behaviors that I'm seeing coming across my desk and the volume of those behaviors has certainly arisen in the last 3 years. That is absolutely true. And in conversations with the U.S. Departments of Education, Office for Civil Rights that I had just yesterday, I asked them, what are they seeing? And they admitted that they have had more cases filed nationally in the last 12 months than in the history of that office, while they're doing the work with 50% less workforce. And my response was, that's what we see too. More issues to handle under these rules with about 50% less people. The turnover in leadership roles in Vermont schools across the state is high. We have early retirements. We have people opting out of the workforce. And so those that remain or those who are taking on these positions need training. And I spend every fall and every spring, I do three-hour sessions. All is new material. Those are not repeats for hazing, harassment, and bullying. And then another three-hour sessions on Title IX sexual harassment. And I see a lot of new faces. Those are offered statewide via Zoom. I would welcome any of you, if you don't have anything else better to do, and I'm sure you do, to come to one of those trainings to understand what administrators are doing. But the reality is if I were, queen or king for a day and able to give schools a tool that could help students immediately, it would be to commit resources to fund positions in every school who are devoted to doing this work, the work that the schools are already doing under the laws you've already passed. You have been at the forefront of this work. Since 1999, you put on the books a peer harassment statute. We are doing the work. It is often a question of resources and time and getting those who are new to the positions sufficiently trained. And VSBIT plays a huge role in providing those trainings up and down the state. And those trainings, contrary to some of the testimony I've heard, are not committed to finding ways to keep schools protected, but informing and educating administrators on the rights of students, understanding the behaviors that implicate those rights, and understanding their own affirmative duties to respond. And on that last point, I just want to emphasize again, schools are not waiting for complaints. They're not allowed to wait under Title IX and Vermont law. Once they have any information, either by witnessing it, hearing it secondhand, having a suspicion, once they in the school system, as I always say, once the information's in the school bloodstream, we have a duty to act. This is not a complaint-driven process. We don't wait for something from the student in writing saying, I want you to do something about this. Under Vermont law, we must act. So schools are doing the hard, tough work, but it does involve an understanding of the rights of all the students involved. And parents increasingly are pushing back when we enforce these rules. They're taking their opportunity, as is their right, to challenge these findings in front of school boards. There is a school board right of appeal, and go to the boards and say, my child did not engage in harassment. I don't want this on their record. I'm concerned that it will stay on their record and prevent them from getting into college. So we need to be very mindful when we in the school do the work that we are doing it properly and carefully. But even if harassment isn't found, even if bullying is not found, if some behavior is happening, which is detrimental to the environment, the school still will respond. So again, I've been going on and I appreciate your patience.
Thank you for the testimony. Questions for Ms. Lynn? So if we were to move forward with this language, what situation, would you summarize by saying there's already so much being done, students in these situations are being captured, Ms. Lynn? And by captured, I mean, the situations are being identified, schools are acting, and that this in some ways isn't at least on the law books, isn't a problem.
No, the school has the tools to respond to the kinds of behaviors that were described to you. The sexual assault in the stairwell, which I think was a New York case.
Yes.
And I say that literally involving me, I was responsible for suggesting to AOE that they add the word sexual assault to the definition of sexual harassment in the model policy. And therefore, since 2015, that has been explicitly considered an act of sexual harassment that requires a school response. We have the tools, we have the definitions, we have the prohibitions. Largely, much of my work relates to educating administrators about the reach and scope of those definitions, and additionally, helping them develop the systems that will allow for consistent, reliable, repeatable responses procedurally within the school system. Like literally, where are the forms? How do those get delivered by a staff member to an administrator for review within the 24 hours that your statute requires? You have a very prompt timeline. Schools are not allowed to sweep these things under the rug. They're required to document what they know and respond within 24 hours. But building that procedural system in a school, there is not a one size fits all. So a lot of my work relates to how do we create those systems? If you pass this law, however, what the law actually does is it says schools can be held legally and financially responsible for the conduct of students whenever the behavior is based on a protected category without consideration to whether or not any, and I'm paraphrasing here, any harm resulted. So when witnesses testify and say, and therefore we think this bill simply encourages schools to engage in alternative dispute resolution with the accused and it doesn't require discipline, that's not the legal reality of what this bill will usher in. If you are saying that after the bill is passed, the requirement that the conduct be shown to impact equal access or substantially and adversely affect equal access, that those are no longer considerations, it just merely needs to be unwelcome conduct based on the student's protected category, you have made the school strictly liable for the conduct of minor students, individuals, again, over whom the school does not have the same level of control that they do for employees. The changes that are going into law that will affect the employee relationships recognize and reflect that level of control. This goes far further. And so when faced with this understanding, schools are then confronted with, if this behavior continues, regardless of the harm it causes, we're automatically on the hook for this. We are incentivized to discipline, to stop the behavior. And yet, the standard in section 570F does not match the standard by which schools are allowed to discipline students at all. So you're creating a really low bar for financial liability, but the ability of the schools to in fact regulate the student's behavior at issue remains under the 26A standard. So I don't want you to make those two pair up, but they are in conflict given the way the bill is written. It creates this unequal standard. You're responsible for that which you're not empowered to discipline. So I see that as a real quandary, and it opens the door to all the kinds of First Amendment liability and litigation that I alluded to earlier. My goal is to have administrators understand the definition, respond and act without having to pick up the phone. If this is passed, on almost every case where there is no discrete effect felt by the victim, they're going to have to always answer the question, do I act? And if I do, am I violating a student's constitutional rights? Because there is no nexus to the educational program or activity that justifies my behavior of regulation. And so it's going to create a lot of questions and concerns. And I think it's counterproductive to the work that, in my view, is already occurring with the tools we already have. The Title IX regulations are going to be substantial. The ones that are already in existence are very robust, require an expansive, deep, comprehensive response by schools already. And the Biden administration is looking to extend the reach of those regulations to not only address and respond to sexual harassment, but all sex-based harassment. That means harassment on the basis of sex stereotypes, sex characteristics, pregnancy, sexual orientation, gender identity. So the entire Title IX construct, which is detailed and intense, is going to be expanded for all of those categories. Understanding and appreciating the reach and impact of those changes, I think, is absolutely vital and prudent before legislating anything that might graft on or complement or augment it.
Okay. Helpful.
Well, I thank you
Yeah,
again.
we're hearing again from the Human Rights Commission tomorrow. Senator Gulick has a constituent possibly that might be available, or you're going to reach out so we can hear a little bit from schools. But this has been helpful. This is certainly been helpful.
I just want to say in closing, I never like being in a position where it appears that an effort to help students is being sidelined or waylaid. It is not my intention to stand for the proposition that students don't deserve to be protected from these behaviors. It is my position, however, that what is proposed doesn't take into account what already exists and may in fact be counterproductive to those efforts. So I appreciate your time and your attention.
If I could just have a final thought. So again, this would impact the school if the school just simply ignored it. In other words, kid is called a name, terrible name, and the school just doesn't act, right? Then that's when it becomes a problem. And by act, I mean, that you can understand where that kid would feel so terrible about being called that name. They're not taking any steps to separate the kids, saying, hey, you're going to sit at this lunch table, you're going to sit at that lunch table. They're really ignoring, right? Help me out a little bit here.
If the question is, what does the school have to do right now before you change this law? And that behavior is witnessed, which largely it would be.
Okay.
The school has an affirmative duty, because of what you've described, to consider and treat that as potentially harassing, hazing, and bullying behavior, to launch an investigation, to send letters home to both the parent of the student who's accused and the parent of the student who is on the receiving end of the behavior, to speak with those students and anyone else who was present, to write up a written report, which the HRC can then review and audit, which the Department of Education can audit, which the Department of Education United States Office for Civil Rights can audit. They are all interested parties and insist that that paperwork would be created and declare whether or not the behavior was or wasn't harassment. And again, even if it weren't, is it damaging and destructive? And if so, what are we going to do to prevent a reoccurrence?
Okay,
That's
so just so I know, Ms. Lynn, before you go on, that is current law. That has to happen school teacher, you witness it automatically, boom.
Yes. AOE's model procedure, page 1, top of the page.
Okay.
Any employee who witnesses the behavior shall immediately report. That is the force of law.
And then those automatically, those letters are sent, that's all part of the statute, it all kind of rolls out from there, okay,
Yes, yes.
it's helpful, it's helpful.
Again, take a look at the toolkit, which creates a narrative of what those duties are and gives you the resources, the actual letters that would go out. It sort of puts meat on the bones and takes it out of the theoretical. That's a Visbit website. Just put Visbit HHB toolkit and it'll pop up.
Thank you very much.
You're very welcome.
With us.
Thank you all for your time and your work. I appreciate it. Take good care.
Committee thoughts, any general thoughts, what we're still fresh.
Yeah, Yes, more testimony.
Yeah, we'll hear tomorrow.
I'm curious,
Or-
the, Boris
Yeah.
response.
Board's response to this type of.
Well, I think general, she wanted to come in again in response to what was said, not put anybody on the spot, but Ms. Siglowski, who represented the group. And so she's gonna come in and respond to that. She has to say. It's an important topic. Yeah, very important topic. We keeping you? Anything else? Any other thoughts on this at this point? Senator Williams?